I'm attorney Michael Ettinger. Today we're going to talk about New York and federal estate taxes. The current exemption from New York estate taxes is $7.16 million, indexed for inflation. In other words, it goes up every year. For most clients, this presents no issue at all. Their estates will never approach the exemption. However, for the fortunate few who have assets, including life insurance, that may exceed roughly $7 million, there is a significant tax liability. Changes in New York estate tax law in the last few years introduced something called the fiscal cliff. Whereas formerly, New York only taxed the amount over the exemption. If you exceed the limit today by a mere 5%, they tax the whole estate. You're over the cliff. The tax is surprisingly large. On a roughly $7.5 million estate, the taxes payable to New York exceed $500,000. An estate over $10 million would owe over $1 million in estate tax. These New York estate taxes are avoidable if you have a spouse and you create an estate plan using two trusts, which doubles the exemption from $7 million to $14 million. This is more fully described in our video Disclaimer Trusts for Taxable Estates. Another way to avoid the fiscal cliff is to use something called the Santa Clause, providing that you gift to charities of your choice all amounts over the exemption. Gifts to charities are deductible from estate taxes. While the federal estate tax exemption of $13.99 million is portable, in other words, if the first spouse doesn't use their exemption or any part of it, it passes to the surviving spouse, New York does not allow for portability. It's use it or lose it. For larger estates, there is a planning opportunity by making gifts. You may use any of your federal estate tax exemptions to make gifts while you are living. These gifts are reported to the IRS and get subtracted from what you may give at death. The advantage of making gifts is that it freezes the estate tax on those gifts. For example, let's say you give $1 million to your children today. You report the gift of $1 million, and the IRS subtracts that from the amount you can give at death. If the $1 million is increased to $5 million by the time you die, then you've effectively given $5 million to your children estate tax-free. One added attraction to gifting is that New York does not tax gifts, so that gifts may also be used to avoid the onerous New York estate taxes on death. There is a minor exception that gifts made within 3 years of the death of the donor are brought back into the donor's estate for New York estate tax purposes.